The President's Management Agenda, or PMA, recognizes that federal employees underpin nearly all the operations of the government, ensuring the smooth functioning of our democracy. The PMA is a comprehensive strategy to make government more efficient, effective, and accountable through 3 pillars: mission, service, and stewardship. The PMA calls for agencies to establish processes that help agencies retain top employees and efficiently remove those who fail to perform or to uphold the public's trust. Today's presentation supports the objectives of the PMA by providing an overview of how to select and write charges for defensible adverse actions. When agencies develop charges based on what they can prove and prepare well-written charges, they increase their chances of prevailing at the Merit Systems Protection Board. Topics covered in this presentation will include understanding the employee relations practitioner's role at the proposal stage, approaches to writing good charges, and understanding common agency charges in the penalty selection process. We encourage everyone to make the most of this webcast training, including asking questions of our presenter. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. We are pleased to have as today's speaker Ms. Melanie Jones from the Justice Management Division at the U.S. Department of Justice. Melanie is a senior attorney with the Office of Labor and Employment Law. That office is responsible for providing guidance to department components on labor and employee relations and overseeing the department's labor and employee relations program. Please join me in welcoming Melanie Jones.
Thank you, Jason. I'd like to thank OPM and Deborah Buford for having me. This is sort of one of my favorite things to do, so I appreciate the opportunity. So let's dive right into talking about writing charges. The objectives of the presentation today will be understanding the ER practitioner's role at the proposal stage, providing an overview of the approach to writing good charges, and understanding some common agency charges in the penalty selection process. So first, let's talk a little bit about the ER practitioner's role. The first step in advising managers is knowing the facts of the case before you get into writing the charge. So that really means in the first instance, when a manager comes to you with a conduct problem, going into the details of what happened, who was involved, so that you can gather the relevant facts in order to begin the process of charge writing. You also need to know, as the ER practitioner, how to research and research relevant regulations and case law. That way you know not only factually what happened, but what legal provisions will support a charge should you go forward. And you've got to know the elements of the charge, of the elements that have to be proven for each particular charge. So let's talk about the proposal notice. And to my mind, the proposal notice is the sort of most important document that you're going to be working on in the process of taking a disciplinary action. It is the agency's chance to tell their story. It's the agency's chance to present the narrative that is most favorable to their position. And it's the agency's chance and obligation to inform the employee of what they've done to merit discipline in any particular circumstance. So what does a proposal notice actually look like? It should include these things: the legal provision under which the action is being proposed, a charge label, specification, the nexus between the misconduct and the efficiency of the service, presentation of why the proposed penalty is reasonable, and the specification of the employee's rights to reply to the proposal. So the authority for disciplinary actions. Most federal agencies take actions under the procedures of 5 U.S.C. Chapter 75 to either suspend, demote, remove employees based on misconduct. Occasionally, Chapter 75 can also be used for unacceptable performance or a combination of those two things. the authority that allows the federal agencies to take the disciplinary action is that it needs to promote the efficiency of the service. So all actions that we'll be talking about today need to include that phrase, and they also need to be for such cause as will promote the efficiency of the service. So there are three parts to a disciplinary action, three parts to a charge. The first is the charge label, which names the misconduct. The second is the specification, which gives you the who, what, when, and where. And then there are the legal elements that support, or the evidence that support the charge. So what is a charge label? The charge label really just provides the framework that identifies the nature of the misconduct. Now, you won't see in the regulations or in the statute a requirement of an actual charge label, but for the purposes of clarity, we suggest doing a charge label that sort of defines for the third party what we're looking at and the reason that we're displeased with a particular employee's misconduct. Examples of charge labels are insubordination, AWOL, which is absent without leave, failure to follow policy, and that could be for your agency, for your division, for your office, and falsification. Now, again, these are just examples. Charge labels can look like anything as long as they're clear with regard to addressing the misconduct that's at issue. Now, the second part of the disciplinary document or the charge is the specification. If your charge is AWOL, an example for how you would do a specification might be your tour of duty is Monday through Friday from 8 to 4:30. Examples of specifications, as you'll see here, specification on July 2, 2010, you reported for duty at 10, and you did not have leave or authorization for your 2-hour absence. Another way to write that, and either way is fine, is on July 3, 2010, you were absent from duty without leave or authorization for your absence. The bottom line with the specification really is that you spell out in enough detail for the employee to know whether or not they've engaged in the conduct that you're describing. So you could say, for example, you were AWOL sometime last year. That would not be an adequate specification because a part of our obligation for giving the employee notice of what they're being charged with is giving them enough specificity for them to respond to the charge. So that's why you are as specific as you can be in the specifications with regard to time, place, and whatever circumstances allow the employee to have adequate notice of what you're charging them with. Yes, question.
Melanie, we have a question regarding AWOL and failure to follow charges. And can those charges be merged, or how can they be used together?
So with regard to whether or not you can merge charges, as a general rule, the board requires you to prove everything that you charge the employee with. So, for example, if you were to call the charge AWOL and failure to follow instructions, you would be obligated to prove both of those things. A better, more conservative approach would be to separate those into two separate charges. So charge one would be AWOL, which would be purely you were absent without leave. Charge two would be failure to follow leave requesting procedures. So, for example, if the employee were to come back from the AWOL charge and say, well, I had medical reasons for my absence and therefore I should have been on approved leave, you would then lose that charge. That charge would fall away. But if you've also added a second and separate charge of failure to follow leave requesting procedures, you can still say that the employee failed to call on time, failed to give proper notice, failed to engage in whatever your procedures are. So that charge would still stand. So the answer to the question is no, you would not merge them because they're different. And you don't want to lose one charge because you've put them both together. So yes, you can use both, but you shouldn't merge them. You should make them separate charges. All right, so moving on, another example, and this is actually timely based on the question, is how you would write a failure to follow leave requesting procedure charge. So if the charge is failure to follow, the specification could be, on July 2, 2010, you failed to request leave for your absence from duty. Or if you wanted to include everything that is in your leave requesting procedure, you could write it the second way, which is on July 2, 2010, you failed to contact your supervisor to request leave as required by this office's leave requesting procedure. Either thing is appropriate. The key to the specification, as I've said, is to give enough information for the employee to be able to respond and enough information for the third party to know whether the employee engaged in the misconduct or didn't engage in the misconduct. So whatever allows you to convey that is appropriate. So let's talk a little bit about how you would choose a charge. The most important thing is charge what you can prove. The facts that you have before you need to support the charge, and the evidence really has to support the facts that have been alleged. So what does that mean? What facts are before you? So one of the things you'll look at is there a governing regulation or rule? Did the conduct actually violate the regulation or rule? Sometimes managers will come to you and they'll say, well, this employee is in violation of a particular rule, and you'll go back and say, well, what did they do? And the manager will give you a recitation of conduct that doesn't actually violate the rule. So your job as the ER practitioner really is to drill down onto every single element that you're going to need to put into your disciplinary action to determine whether there actually is misconduct. And once you do that, you can then craft your charge and craft your specifications that actually match the facts that you have before you. So another thing, managers sometimes like to accuse employees or allege employees have engaged in failure to follow a direct order. So the relevant question for you as the practitioner is, well, was there an order? If there was just a suggestion or just an intimation that something should be done, then in fact you don't have an order, so you wouldn't be able to craft a charge that involved disobeying an order or failure to follow. Facts and evidence. Evidence can come in a number of different forms. It can be physical, it can be documentary, it can be testimonial. An example of testimonial evidence is you can have several employees who've witnessed a particular misconduct. You would obtain affidavits from those employees or statements from them. Documentary evidence or actual evidence might be time cards. If you're having an AWOL charge, then evidence in terms of when an employee signed in or out with their time card could be evidence. But the evidence should always support whatever you're alleging happened. So if you're talking about property damage, then you would need to have evidence, either the property itself or some representation of the property that was actually damaged. Are there documents that reflect the misconduct? Are there documents where there are misrepresentations made in writing? Did someone witness the misconduct? Did an employee admit to the misconduct? All of those things are elements of evidence that you as the practitioner needs to gather in order to decide, one, how to craft your charge, and two, how to write your specifications in support of that charge. Question?
Yes, Melanie, can you please address stacking of charges? What is meant by that?
Stacking of charges is, I guess, to be distinguished from, maybe it's the same as piling on of charges. So stacking would be sort of using the exact same set of facts and just using a different charge to support those facts. Now, there's some times where like stacking, and I'll put that in air quotes, is appropriate. So for example, if you have an employee who is misusing their government computer and looking at inappropriate material during work hours, the same set of facts might support two separate charges in that example. So they're looking at inappropriate material, which is one charge. Misuse of official time would be a separate charge, and the specifications under those charges might be very similar or the same, because if they're looking at inappropriate material during work hours, the inappropriate material is one charge, and the looking at things during work hours is another charge. So you can have very similar facts under separate charges, which is permissible. What you shouldn't do is try to pile on charges that are roughly the same thing just to sort of boost the penalty or to make it appear that the conduct was more serious than it was. But it's certainly appropriate to use similar or sometimes the same facts to support different charges if you're really talking about different misconduct that has occurred in one instance. So moving on to framing the charge. We've talked a little bit about what the purpose of the charge is, and we like to suggest that the charge be brief, doesn't need to be a paragraph, and it shouldn't be even a sentence because, again, you have to prove everything that you put in the charge. If you choose to structure your disciplinary action with charges and with specifications, you have to prove everything that you charge. So brevity will keep you honest in terms of making sure you can prove everything there. Clarity. Clarity is vital. And, this session is the essential guide to building defensible charges. But in addition to prevailing before the MSPB, our obligation as practitioners is to really put employees very clearly on notice of the nature of their misconduct and the nature of why we as the agency are dissatisfied with that misconduct. So for litigation purposes, clarity is vital, but in terms of actually accomplishing our mission of being clear and putting employees on notice and therefore getting better behavior, clarity is important. And we talked just a moment ago in the question about combining charges. Don't combine them, but if there are two charges that cover the misconduct, use two charges. Yes, question.
Melanie, a related question deals with using conjunctions in a charge label, such as causing anxiety and disruption in the workplace. Can you please discuss the pitfalls of using conjunctions such as and?
Sure, that really goes back to first principles is you've got to prove everything that you put in the charge. So for example, causing anxiety and what? And disruption? Okay, so in that charge, you would have to prove that the employee disrupted the workplace and that they caused anxiety. Now, whether or not you can ever prove that someone caused anxiety is a sort of a separate question, but if you make that conjunctive charge, you're then responsible for proving both of those things. If you fail to prove, for example, that they caused anxiety, but you do prove that they caused disruption, you will lose that charge because the board is not going to split the charge for you. So unless you can prove everything that you've charged, you will lose the entire charge. If you wanted to charge, again, whether you would want to charge someone with causing anxiety, you would make that two separate charges, and then you would have specifications that went to each word and supported the actual definition of both anxiety and separately the definition of disruption. All right, so let's talk and look at some common agency charges, and we'll start with some leave-related offenses which are fairly common. Absent without leave. The elements of absence without leave are the employee was required to be at the duty station, they were absent, and the absence was not authorized, or leave request was properly denied. Now, just by way of noting, AWOL in and of itself is not necessarily a disciplinary matter. AWOL is a time designation. You can discipline an employee for being AWOL, but just because you mark someone as AWOL because they weren't at work doesn't mean that they're by definition disciplined. So AWOL as a charge has to be actually put forth as a disciplinary matter. Yes, question.
We have a question concerning the way charges are listed on the proposal. Is there any significance to the order in which charges are listed? Does one listing a charge first give it, for example, greater weight than another charge?
Not necessarily. I mean, my practice is to list the most important and best supported charge first because, again, you're writing for two reasons. You're writing for the employee to put them on notice, and you're also writing for the third party, and you want the third party to understand what you as the agency views as the most important charge. So I would front load my charges with the thing that is sort of most serious and go from there. Now, there are some times when logically you might list charges in a certain way. For example, if I'm charging AWOL and failure to follow leave requesting procedures, I might put the failure to follow first and then put the AWOL second because that you're sort of setting the stage for, well, first you didn't call and tell me you weren't coming, and the result of your failing to call and tell me you weren't coming is that you were AWOL. So sometimes there's a logical order, or sometimes there's even a chronological order that makes you need to list one charge first, but as a general rule, there's no preferred way, just do what makes sense in the context of your document. Practice note, going back to the AWOL charge that you should be aware of, is that an employee can defend against an AWOL charge by presenting medical documentation that they were incapacitated for duty. They can do that up to the moment of the board hearing. So that is, again, another reason why if you have an AWOL charge and if you can support a failure to follow charge, you should do both. Because even if your AWOL charge falls away, you still have your failure to follow leave procedure in place. Now, I will caution you, if you're going to charge failure to follow leave requesting procedures, your manager has actually needs to have leave requesting procedures. Don't get to the end of the day or get to your hearing and find that even though that was the charge, there's no actual leave requesting procedure in place. So that goes back to doing good research, doing good footwork at the beginning of your conversation so that you know exactly what evidence you have to support your charge. Second practice note is an employee might also establish an entitlement to FMLA during a period of AWOL, at which point you might need to go back and either revise your charging document or decide that you aren't going to pursue the AWOL charge. But that would be, very fact specific. All right, we talked about this a moment ago, failure to follow leave requesting procedures. The elements are the agency has a procedure for requesting leave, the employee knew or was on notice of the procedure, and the employee failed to follow them. So that's really it, which is why it's a fairly easy charge to prove if you've got all those elements and if, in fact, your manager had leave requesting procedures. Excessive absence. This is a charge that really only comes up when you're looking at medical absence for medical reasons. And the elements of this charge are absent for compelling reason beyond the employee's control, so that whether or not you've approved or disapproved the leave really is immaterial. The employee absolutely could not report for duty. Next element is that the absence continued beyond a reasonable time, and the employee was warned in writing that adverse action might be initiated if they're unavailable for duty on a regular, full, or part-time basis. And finally, that the position needed to be filled by an employee available for duty on a regular, full, or part-time basis. Yes, question?
There's a question concerning medical documentation. What if an employee has no accrued leave available and is not eligible for FMLA? Would the AWOL charge still stand?
If the employee has no leave available, so yes, the AWOL charge could still stand because they're not in an approved leave status. You might then decide in a particular circumstance to either advance the employee leave or to put them in a leave without pay status. If you've got an employee who is, because of a medical condition, absent, that's where you might then look at an excessive absence charge. So at that point, you would be approving the leave, but you still might be looking at removal for excessive absence if the employee meets all of these criteria. If you've given them the warning that their failure to become available could result in adverse action, and if you've done what we call the Cook warning and done all those things and said that you need them to fill their position on a full or regular part-time basis. Yes.
With respect to AWOL, do we need to list every day of AWOL as a separate specification?
As to whether you list every day of AWOL as a separate spec becomes sort of a matter of practicality. If you're talking about separate days and perhaps separate pay periods, then for clarity, yes. And again, going back to first principle, what you want to do is put the employee on clear notice as to what they're being charged with. So you can't just say you were absent for 4 days last week. You would have to say you were absent Tuesday, Wednesday, and Thursday. However, if someone has been absent for a month in a row, I wouldn't see any reason not to say you were absent for the entire month of July. Your tour of duty was X, and you'll list the number of hours. So again, that becomes a matter of being practical. It wouldn't make sense in that case to do 25 days of AWOL as separate specs if they've been consecutive, and if you can make it clear what you're talking about. It becomes a matter of practicality and clarity. Question?
Also, a question has come in to ask, are there different requirements for a proposal notice for an action that is appealable to the board versus minor discipline that would not be appealable?
Tell me the first part of that.
Are there any differences in the requirements for a proposal notice?
Proposal notice, the differences in what I call the term of art adverse action, which is 14 days or more removal or demotion. You should always include in those proposals the 30-day notice, which is not required in suspensions of less than 14 days. That just has to be reasonable notice to the employee, which has to be at least 24 hours, but beyond that, it's at your discretion. Because things aren't appealable to the board doesn't mean you shouldn't still do them in a way that is clear and brief and follows all the same rules. But the requirements in terms of notice to the employee really go to how much notice you have to give them before you might take the action, if that's responsive.
One more question at this point. Can you merely use an employee's admission of misconduct as the basis for your evidence, or do you need to develop and flesh out all of the evidence to support the charge?
You can certainly use the employee's admission of misconduct as evidence. If there are other elements or other types of evidence that also support, I would certainly flesh them out, particularly if you're looking at evidence that supports a more harsh penalty or a different penalty. So yes, to answer the question, yes, an admission is certainly proof, but if you can have supporting evidence that bolsters that, or that should the employee at some point decide to recant, you would need to at least have the evidence available to you should it become necessary, and certainly with regard to reasonableness of penalty. All right, the next type of charge, or the next possible charge label, is medical inability or unavailable for duty. And the elements of this are similar to excessive absence, but they are slightly different in some ways. Employee is physically or mentally unable to perform the job. Sometimes if you have medical standards or fitness standards built in the position, you would have them sent for a fitness for duty exam. If you don't have medical or physical standards, you would need the evidence from the employee's own private physician. And finally, the employee's medical condition is always relevant even after the fact, which means that if you charge medical inability or unavailability for duty, and the employee becomes better, if the medical condition resolves itself, even up to the day of hearing, then they can be reinstated, because that was the whole basis on which you removed them. So if they are then suddenly able to report for duty and become available for duty, that is irrelevant all the way up to the end of the process. One thing that you should note when you're making this charge, if an employee is in fact saying that they can't perform the essential functions of their position, and that's the basis of your charge, you need to make sure that you've examined all of your reasonable accommodation options, that you've offered them or at least explored the option of reassignment, so that when you make the charge, you're able to document all of that for the record and include all of that in the proposal. Another charge, misuse or unauthorized use of a government vehicle, and by that I don't mean the conjunctive charge. I mean you can charge misuse of a government vehicle or you could charge unauthorized use of a government vehicle. You wouldn't combine them. Government property is any form of real or personal property in which the government has an interest. Some of the examples are office supplies, the telephone, the computer, other types of equipment, mail, printing facilities, government vehicles. Misuse is when the property itself is used for purposes other than those for which the property is made available to the public or other than those authorized by rule or law. The fact that an employee did or intended to pay for the use of the equipment doesn't negate misuse. So it doesn't mean that if someone uses your copy machine for the church bazaar, they can then give you $15 and say, hey, I bought the paper. If you're going to charge misuse, you should make sure that you're being consistent. Be sure that you're at least making a distinction between de minimis use and misuse that you find wasteful. The other thing is make sure that you are making this charge consistent among all of your employees and enforcing the rule evenly across all of your employees. Yes.
Is there a distinct difference between the strength of a signed statement versus a sworn statement?
I don't know that there's a difference. Presumably, a signed statement is attesting to the accuracy of whatever is in the statement. A sworn statement under penalty of perjury might carry more weight and would certainly be something that I would prefer. But by signed statement, I guess I'm not really sure what you mean, whether the signature, what the signature denotes, as opposed to a sworn statement. Mm-hmm.
You mentioned the Cook warning. Could you explain what that is, please?
Yes, the Cook warning, and if we can bounce back to the slide. It is from the MSPB case Cook versus Army, 18 MSPR 1610. And it is the warning that needs to go to an employee before you can charge them with excessive absence. And again, it is as set forth on the page that they have been absent for compelling reasons beyond their control, that the absence continued beyond a reasonable amount of time, and that they've been told that their absence has continued beyond a reasonable amount of time, and that if it continues and they continue to be unavailable for duty, either on a full or part-time basis, and finally, the final point in the Cook warning is that you inform them that their position needed to be filled on a full or part-time basis. So that warning needs to precede the charging document or needs to precede the proposal for removal if you're going to charge excessive absence. Mm-hmm.
If the agency has one specification and it covers the period of time of a whole month, if the employee provides medical documentation for some of those days, will the charge still stand?
So if the spec covers a full month, will the charge stand? If it's the only spec in the charge might fall. So that's why you need to sort of be strategic about whether you're going to group. I'm assuming that the question refers to AWOL charges. So if you're going to group your charges, if you're going to group things in your spec, you need to make sure there are other specs that if one particular spec falls away, you can still support the charge. Now, keep in mind that if the employee comes with medical documentation, it's proper that the charge fall away. So you might need to decide strategically what days you're going to group, what days you're not going to group. Presumably, you might have some medical documentation of some absences already, and so you wouldn't include those in your AWOL charge. So that becomes a strategy question, I would say.
If an employee was found to be showing up hours later than what they had reported as their start time on their timesheet, what would be the best charge to use? Inaccurate time reporting, AWOL, or something else?
If an employee's showing up hours later and they're not in an approved leave status, it would certainly be appropriate to charge them with AWOL. And then you could also do a separate charge if they have reported that they were there. So again, that becomes a factual question. If they just showed up, but they signed in, accurately, if they're supposed to be there at 8, but they signed in accurately at 9:20, then you would just charge them AWOL. If they're supposed to report at 8, they show up at 9:20, but on their sign-in sheet they say they came at 8, then that would be inaccurate reporting. So you can charge both of those things, assuming that the facts support the charge of inaccurate reporting.
Does an employee have to submit medical documentation to the board within 30 days of their filing their appeal, or with any other prescribed period of time?
I don't know that off the top of my head, but I believe that you can submit the medical documentation up to even the point of the hearing. Okay, all right. So another example of a charge is misuse or unauthorized use of an official government vehicle. Now, this is a statutory charge, and I included this in the slide set because if you charge under the statute, if you charge unauthorized use, then the conduct has to be willful or taken with reckless disregard. If you charge under the statute, it imposes a minimum 30-day penalty. So that is a charge that once you've proposed it and once you've proven it, your deciding official cannot mitigate this and say, oh, this employee is a great employee. Yes, I find that he engaged in the misconduct, but I'd like to mitigate. Once you charge under misuse of the unauthorized use of the official government vehicle, you are stuck with the 30-day penalty, and your deciding official can't mitigate. So that's an important fact for you as the practitioner to know and advise your managers accordingly, that if they don't really want a 30-day suspension, then they should charge misuse or failure to follow an instruction or something that is not citing directly to the statute.
You mentioned the deciding official. Are there any advantages or disadvantages when the proposing and deciding official are one and the same?
The disadvantage of having the proposal and the deciding official be the same is you open yourself up to claims of bias. Now, there's not a regulatory requirement that you have a separate proposing and deciding official, but certainly an employee could say, well, of course, you proposed something and you decided it and you didn't really take into account my reply because you're the same person. So the advantage would be charge of bias or a sort of pre-decision ruling. That would be the disadvantage. I don't know that there's an advantage other than you're just dealing with one person, but certainly if you can bifurcate the process and have two people looking at it, you have a better chance of escaping that type of allegation by the employee.
With respect to the Douglas factors and a charge of excessive absence, are the Douglas factors required since it's a medical condition, or would you consider that Douglas not necessary?
That's a question I hesitate because that's a question we've been discussing a lot in my office. Douglas factors are not strictly required. However, I don't think there's a downside to including some Douglas factors in the proposal Particularly if you've got something in addition, a charge that's in addition to the excessive absence, so that the deciding official has access to all the information that the proposing official has. Now, if you're going strictly on excessive absence and you want to go with just the medical documentation and the facts that we've discussed with regard to the Cook warning, that's certainly something that you can do. I tend to err on the side of at least minimally covering some of the Douglas factors, just as a matter of practice and a matter of completeness, but whether it's strictly required, it isn't. So if you wanted to go forward without them, it's legally sufficient, with air quotes. Yes.
In terms of witness statements, is it necessary to redact the name of witnesses in the evidence file when issuing it to the employee who's been charged with the misconduct?
As a general rule, I would say no. The employee has the right to look at all evidence that you've relied upon in coming to your proposal, and certainly when you with regard to the decision. So I don't know that it's necessary or even a good idea to redact the names of the witnesses. Okay. All right. Now we've talked a lot about charge labels, and I'd like to move on and talk a little bit about the difference between intent-based charges and non-intent-based charges. And the reason that we make that distinction is, again, as we've said, you've got to prove everything in your charge and all of the elements and definitions of the charge. So charges that require you to prove intent, examples are as follows: falsification, which requires you to prove knowingly supplying wrong information with the intent to deceive or mislead. Insubordination, willful and intentional refusal to obey a lawful order. Theft, taking with the intent to deprive the owner permanently of possession or use of his property. So, as you can see, if you make one of these charges, you've got to prove what the employee was thinking, deciding, intending. And if you can do that, fine. If you have evidence to support that, fine. But if you can't, then you will lose the charge. An alternative to intent-based charges are charges that don't require any intent at all. For example, submission of false, misleading, or inaccurate statement. That encompasses every possibility. It doesn't matter what their intent was. It only matters that the information they submitted was inaccurate or false or misleading. Lack of candor focuses on an employee's duty to be forthcoming in response to facts and information in their possession. I think of lack of candor as a little bit of a hybrid, because you do have to show sort of an intention to withhold or to not be fully forthcoming, but it's not as intent-based as, say, falsification. So lack of candor generally applies when an employee is being asked a series of questions and is answering accurately but not fully. They're not giving forth all the information that's available to them. Another non-intent charge is failure to follow instructions. The elements are very simple. A proper instruction was given and the employee failed to follow that instruction. That's the long and short of being able to support that charge, which is very different from insubordination, where you have to prove that the employee was intentionally failing to follow a particular instruction. Improper associations, again, you don't have to prove that the employee intended to do something improper, that they intended to associate in a way that jeopardized their position or that was against the mission of the agency. Personal, unprofessional, or off-duty relationships with people that might impact on the agency's mission can lead to a charge of improper associations. For example, if a DEA agent is associating with convicted drug dealers or with people who are known to engage in the drug industry, that could be charged as an improper association, again, because you would be able to show that the very mission of the agency was compromised by this person's relationship with the other person. conduct unbecoming. Great umbrella charge. It really just has to show that the employee behaved in a way that was unbecoming for a federal employee or that was inappropriate. One example is people who are in public life and are abusive to the public. For example, receptionists or people who greet the public. If they're behaving in a way that's rude or inappropriate, you would charge them with conduct unbecoming, and then in your specifications describe in detail what the nature of their misconduct was. Now let's talk a little bit about loaded words, because in making the distinction in your charges between intent and non-intent, some people will try to sneak in some what I call loaded words into either the specification or into the narrative. If you try to sneak those words in, you knowingly, willfully, or maliciously engage in this misconduct, the board is going to look at those and say, well, it wasn't in the text of the charge. However, everything you're saying leads us to believe that you're trying to boost your penalty and trying to boost your charge by adding these intent-laden words. So stay away from those words unless, again, you have evidence to prove them in terms of supporting the use of those intent-laden words. Question?
Yes, we have a couple of questions regarding the Cook criteria. One is asking, how far in advance do we need to issue the Cook letter?
With regard to in advance, I would say do it in roughly 30 days in advance, because you know, again, looking at the circumstances under which you're going to be charging excessive absence, you're looking at an employee who is in a medical situation that they can't control. So you already know, presumably, that they don't have any ability to come back. So you have time to send the Cook letter, give adequate warning, give adequate time for them to respond that they cannot return or not to respond at all, and then go ahead and do your excessive absence. So a month, I would say, is a reasonable amount of time for that.
Related to that, a question is asking, how long after issuing the letter of warning under Cook criteria must the agency or should the agency move forward with proposing the removal?
So that's kind of the same question. Once you've given the Cook letter out, give the employee a reasonable amount of time to respond, maybe 2 weeks, and then say in the absence of a response or in light of a response that indicates that they can't make themselves available, you could then move forward. Mm-hmm.
Who pays for exams, such as the mental exams or physical exams that the agency requires?
If you've got medical standards and you're sending your employee to your own doctor, then certainly that cost is covered by the agency. If you are asking for medical documentation because you're not sending them, you're saying, please indicate your medical status, that cost falls to the employee.
Also, Melanie, how do you recommend addressing or charging leave restriction violations if the employee invokes FEMLA, or Family and Medical Leave Act leave? Is removal still an option if FEMLA is in effect?
You can't remove an employee who is actively in a FEMLA status if you're removing them for the absence covered by FEMLA. So, for example, if you're saying you've been absent for 30 days, but those 30 days are covered and already approved as FMLA leave, you cannot use those as a basis for the absence. If you're talking about leave restriction, that's really a separate matter. The leave restriction has certain reporting requirements and certain elements certain steps the employee is required to take in order to take a leave. So certainly you could discipline them for failure to follow the leave restriction, but you can't discipline them for taking their approved FMLA leave.
Another question, and this regards placing a charge with an employee who has been charged for an offense and disciplined for that offense. Subsequently, the agency finds out that there were more instances of the same offense during that same time period, but they've already been disciplined. How do you address those additional instances of misconduct?
I would say if they're items of misconduct or instances of misconduct that were not covered, that for which the employee hasn't been disciplined, you could discipline them if the discipline has already been served. If it hasn't been served, if you're just at the proposal stage and even at the decision stage, but they haven't served the discipline, you might then rescind both proposal and decision and come up with a new charging document that included all of the conduct of which you were aware and adding in all of the new conduct of which you've just become aware to create a new charging document. If they've already served, then you've got to decide if you're going to go back into that same sort of pre-discipline period of time and discipline them again. I think you might run into problems of if you trying to use progressive discipline, you'll have to suss out the issues of notice, because you won't be able to say that they were on notice or that they had been disciplined before the misconduct because they hadn't been, because you were unaware of it. So those are sort of strategic things that you'll have to be mindful of if you decide to sort of go back into the past pre-discipline.
If the agency recently discovered that an employee was arrested for off-duty misconduct, and the arrest was for driving under the influence, but the event happened several years prior, would the agency charge the employee for failing to disclose this event?
That sort of depends, and one sort of key factor, regardless of the time at which the conduct occurred, is whether there's a reporting requirement. So if your agency has a disclosure requirement that requires employees to report interaction with police or to report arrests, then you might well look at something that is a year or more old, particularly if it's relevant to the mission of your agency and if the failure to disclose is relevant to the mission of the agency. So it would be less a matter of whether the off-duty misconduct had a nexus and more a matter of whether the failure to report had a nexus, even sometime in the past, particularly if you're just becoming aware of it.
What is considered reasonable or unreasonable regarding excessive absence?
If by time frame, the time frame of the absence, there's not really a bright line rule that defines that. If you're discounting all of the FEMLA absence and you're just counting absences that started after FEMLA, I look at absences of 90 days or more. And again, you also might look at what the employee's medical documentation is actually saying with regard to the expectation of recovery, expectation of being able to be available for duty. You can certainly send out the Cook letter and the employee may come back and say, I'm really not able right now, but in the foreseeable future, I will be able to come. And so that might be something you take into consideration.
Melanie, with regard to testimony, either written or oral, to substantiate a charge, can unsolicited testimony be provided and accepted? For example, if word gets out that an investigation is underway and someone comes forward with key information seeking to offer key testimony, could that be accepted?
I would say any type of evidence would be acceptable. With regard to how much weight you would give it would really be the decision of the deciding official in the first instance and perhaps the third party in the second instance. So if you are the ER practitioner and someone says, hey, I heard you were looking into X, Y, or Z, I have information, you would certainly take that information in the same manner that you take anyone else's statement and then the deciding official would decide what weight to give that based on either the source of the information or the timing of the information. But certainly I wouldn't ignore it just because it was unsolicited.
Also, we want to know, are there any legal limits or strongly suggested guidelines as to how long management can take in following through on an action? Once they have developed their record and they know that they can prove the charge, how long do they have before they actually propose the action?
I don't know of a hard limit. My recommendation would be as soon as you can pull together your charging document. It's certainly, again, going back to first principles of notice and fairness to the employee, you want them to be able to respond, so you would want to charge them within a reasonable amount of time that they could recall the events for which you're charging them. But sometimes you don't find out about misconduct until long after it's happened, and your becoming aware of it sort of belatedly shouldn't prevent you from taking the action. But certainly as soon as you're aware of it and can pull together your charging document, you should issue the charging document.
With regard to surveillance pictures or videos, can these be used in an AWOL case?
If they're relevant, if you have a surveillance video that sort of shows a time clock in the same shot as the employee, walking down the street away from the office, certainly anything, again, can be submitted as evidence. What weight it is given really will depend on the nature of the evidence and what the deciding official believes the evidence shows, and ultimately what the third party believes it shows. But certainly, visual evidence is evidence.
Another question regarding the Douglas factors and when they're used. Would the Douglas factors be used for misuse of government vehicle charge?
So I'm assuming the question, for unauthorized use of a vehicle, if the statutory penalty has to be followed and you're looking at 30 days, would you do Douglas factors? That's a good question. I hadn't thought of that, but I always would do Douglas factors no matter what, even though the deciding official can't mitigate. Is that it? Okay. All right, so let's talk about the Douglas factors and penalty considerations. Douglas factors is sort of the short-term way that we refer to criteria and elements and items that the deciding official looks at in deciding whether a penalty that's been proposed is reasonable. And they come from the case of Douglas versus Veterans Administration, 5 MSPR 280. So the takeaway for the Douglas factors is they're mandatory to consider all of the factors that are relevant. Not every Douglas factor that's listed is relevant in every case. And so as the proposing official, and certainly as the deciding official, you have to use your judgment and look at the factors and match up to the facts and the charges at hand to see which factors are relevant and which factors are not. Best practice is to formally articulate your consideration of all the relevant factors so that the employee understands what you've considered with regard to coming to whether or not the penalty is reasonable. So let's go through a few of them, and we'll talk about them. One, and to my mind, sort of one of the more important ones, is the nature and seriousness of the offense and its relationship to the employee's duties, positions, and responsibilities. So what does that mean in English? It means how serious and how big a deal was what the employee did. So if you're looking at a penalty that is a long suspension or a removal, was the conduct in which they engaged so serious that it would be reasonable to remove them for engaging in that type of misconduct? Number 2 is the employee's job level and the type of employment, including their supervisory or fiduciary role. So when you look at that is, well, are you a supervisor? Supervisors are held to a higher standard than line employees, and does the misconduct immediately impact on that person's ability to supervise well or on their ability to serve as an example for their employees? 3, the employee's past disciplinary record. Is this the first time for which they've been for which you've disciplined them for this type of misconduct? Or are they sort of a repeat offender that is disciplined frequently? Those are all relevant to the consideration of whether a penalty is reasonable or should be mitigated. 4, the employee's past work record, including length of service. Deciding officials and also third parties are allowed to say an employee has been with the government for 27 or 30 years, and therefore they're going to mitigate the penalty because long service is worth something. So that's an important thing to include in the document. The impact or effect of the offense on the employee's ability to perform at a satisfactory level. If the misconduct means that you can no longer do your job well, that's an important factor in considering, what the penalty should be. Number 6 is consistency of the penalty with those imposed on other employees for same or similar offenses. And we'll talk about that in detail a little later. 7, consistency of the penalty with applicable table of penalties. 8, notoriety of the offense. And that means, did the offense or the misconduct draw attention? Was it discussed in the newspaper? Did it receive coverage outside of the agency? And 9, the clarity with which the employee was on notice of the rule. 10, potential for rehabilitation. 11, mitigating circumstances surrounding the offense. We'll talk about that a little later. And 12, adequacy and effectiveness of alternative sanctions to deter conduct in the future. So let's talk a little bit about nature and seriousness of the offense. Again, this to me is really the main thing. How bad was it? Is it worth a 14-day suspension, or is it worth the removal? That's what the proposing official has to articulate in the proposing document to indicate to the deciding official and ultimately to the third party that the penalty suggested is reasonable. Past discipline. We talked about this a little bit before. If it's a first-time offense, then perhaps that's a mitigating factor, and the deciding official or third party wants to reduce it. If it's a third offense or a fourth offense, perhaps then a removal is the appropriate penalty because nothing else has worked with this particular employee. So we were talking about the employee's position. Factors considered are the employee's job level and the type of employment, which might include their supervisory or fiduciary role. So what does that mean? It means that the supervisor is engaging in misconduct. You can certainly include that, and we call that an aggravating factor, which means it's just one of the factors that you would list in support of what might be considered a harsher penalty. If you're discussing erosion of supervisory confidence in support of the penalty, you've got to be able to articulate a relationship between the misconduct and the position. You can't just say, let's say with regard to a receptionist, your misconduct really eroded my confidence in your ability to be a receptionist. You've got to actually support why that's important if you're going to include it in your analysis and in your penalty discussion. Likewise, I would suggest that if you are talking about an erosion of confidence, but you're talking about a suspension, you're going to have to explain after the suspension how that confidence is going to come back. So save the things like you've eroded my confidence, you've destroyed my ability to trust you for for things like demotions or actions like removals, that that your penalty is consistent with the verbiage that you use. Don't say you've eroded my confidence and I can never trust you again, see you in 2 weeks. That's not logical. It's likely not to be really taken seriously if you've included it in a suspension when you're really using language that seems to indicate it's appropriate for a removal or a demotion. Employee's work record, past evaluations, awards, and accomplishments, certainly mitigating factors that a deciding official could use to say, look, this has been a good employee and they've done great things, they just had a misstep. So you should certainly include and discuss those, and they're fair game for your deciding official and the third party to look at. So this is really just an example of what a penalty discussion might look like. In determining the penalty, I've considered a number of factors, including your employment history, you have almost 13 years of service, and you've received satisfactory performance. Based on your lengthy service and good performance, I choose to mitigate the penalty. Or if you find that none of that stuff impacts you enough to mitigate, you might say, however, these factors don't outweigh or mitigate the gravity of your misconduct. Another example is, as noted above, you were suspended for 4 days for AWOL and failure to follow procedures. You've also been subject to leave control restrictions twice. In addition, I've considered the fact that the misconduct was repeated over an extended period of time. Now, this is just an example of how you weave in all the things that, if it's in the proposal, the deciding official then can weave them into his decision and make clear why he's chosen not to mitigate a penalty. Another example goes to the reliability and the nature of the position. Reliable, regular attendance at work is an expectation that applies to any employee. As you're the legal administrative specialist assigned to me, your presence is particularly important. Again, you're supporting why you're sustaining a certain penalty. Now, alternative sanctions. Some people get this confused, and deciding officials in particular will say with regard to alternative sanctions, well, I didn't want to consider anything else, I only considered removal. You have to consider alternative sanctions. That's one of the requirements. But considering an alternative sanction doesn't mean you choose to accept it or to take it. You've got to be prepared to discuss, yes, I considered suspension, I considered demotion. However, based on the nature of the conduct and all the other things we've discussed, I find that removal is the only sanction that I think will be effective. So you've got to include that you considered. You can say, yes, I thought about it, I decided otherwise. That's what the alternative sanction discussion looks like. So I think that takes us to the end of the slides, certainly willing to take other questions. And if there aren't any questions, there are some questions.
If an employee is assigned work or duties and instructed to perform those duties, fails to complete them, can that be addressed as disciplinary and performance? And the questioner says that normally we try not to mix discipline and performance issues together.
Well, if an employee is failing to perform their duties to the extent that there could be said to be negligent or just failure to execute certain instructions, then that would be a Chapter 75 action. The fact that it's Chapter 75 doesn't mean it can't address performance. It just means you have a different burden of proof than if you were charging under Chapter 43 and going through the PIP and removing or demoting for unacceptable performance. You can say your misconduct was X, Y, and Z, even if it relates to the performance of their duties. You're just taking that and addressing that failure under Chapter 75.
If an employee is barred from their duty station, can the employee be charged with failure to meet a condition of employment, or should the agency charge the employee for the misconduct that resulted in them being barred from their duty station?
If they're barred from their duty station because their clearance has been suspended, you would charge them, not suspended, but revoked, excuse me. If their clearance has been revoked, you would charge them with failure to maintain a credential required for duty. If that's not the case and you just don't want them at the duty station for reasons that have to do with the misconduct, you would charge them with the misconduct. But barring from a duty station is generally related to the suspension or revocation of a clearance.
Again, regarding the cook warning, how do you move forward if the subsequent absences or the absences are intermittent? The individual has already received what the agency terms as a cook warning, but there are subsequent absences which are intermittent.
So I would assume if the absences are intermittent, then they're interspersed between instances of attendance. And at that point, you would look to see whether the medical condition is causing the absence, whether they're available on a full or part-time regular basis. And that's what you would look to. Perhaps you would have a different charge that might be more akin to medical inability if they aren't able to engage in reliable, predictable attendance.
This question concerns an employee who is not maintaining a clean and safe workspace, and the agency wants to charge them or discipline them for this misconduct. And the agency is asking if there are any additional actions that should be implemented after the suspension is served to ensure the employee cleans his or her office and maintains it as such.
Well, you can only give instructions and either they're followed or they're not. So if the instruction is to remove something or to keep a workspace in a certain condition and that instruction is not followed, then you would engage in progressive discipline as necessary. So I don't know that you can guarantee that an employee will do anything, but you can certainly discipline them for failure to follow the instruction.
With respect to the charge lack of candor, if an employee repeatedly responds to questions regarding suspected misconduct that they do not recall, is that considered lack of candor?
Well, you would still need to be able to mount evidence that refuted that they didn't recall. So you might have to have had them, giving information to someone else, or giving information, or another witness who knows that they were present or recalled. So it could be lack of candor, but in order to prove the lack of candor, you would still have to prove something with regard to their response.
How far back can an agency reach for prior history of discipline?
Suspensions are in the OPF forever, as are demotions. Reprimands, I believe, stay in the OPF for 3 years. So you can reach back forever for a suspension and a demotion. You would want to look to whether that particular misconduct was similar to the misconduct that you're charging with now and decide how relevant it is and what weight to give it. But they're certainly available for use of progressive discipline as long as you've got the OPF. I would say they just need to be relevant. You would need to tie in why you're mentioning them. Now, if they're very similar, they could also be used for purposes of notice so that an employee is not in a position to say, oh, I had no idea that was misconduct. You can go back forever and say, no, we've had this conversation before. You've been disciplined before. You certainly were aware of my expectations.
Do you recommend using the Douglas factors in a narrative in the proposal or just attaching a worksheet where the factors were considered?
I think you can do either. The narrative, particularly in the proposal, strikes me as the more persuasive way, particularly if you want certain things considered. But either thing is fine to show that that they were considered, and particularly for the deciding official, as long as he has access to them and knows how they were considered with regard to the penalty, that's the important thing with presenting the Douglas factors.
Must you consider the Douglas factors when proposing an adverse action?
The Douglas factors have to be considered with regard to assessing the reasonableness of penalties, so yes.
If a supervisor is disciplined by suspension for 10 days and by demoting them for the same facts, can that disciplinary action be supported?
Yeah, so you can suspend someone and demote them.
Is years of experience always supposed to be a mitigating factor for Douglas analysis purposes? What if a person has violated a leave policy and has worked at the agency for 20 years? Isn't it reasonable to assume they should know the policy?
You can't use years of service as an aggravating factor, that has to be used as a mitigating factor. But you can always say you are on notice of this policy. You can't say you've been here forever, so you must know that this is how we do things.
Regarding ex parte communications between the proposing official and the second line supervisor, when does that occur? Is it strictly between the proposing official and the deciding official? Ex parte communications, is that only between those two individuals?
So ex parte communication really means that the deciding official has received information from something outside of the record, outside of the proposal. So it can be information from the proposing official, it can be information from someone else in the office, it can be from Google. Ex parte communication really means that the deciding official is looking at something that's not in the record. And the reason that becomes an issue is because the employee's right is to have access to everything that formed the basis of the proposal and everything that the deciding official considers in making his decision. So if there's outside information that the deciding official is considering, he's in fact violating the employee's due process rights. So that's why the ex parte problem exists. It can be cured if the deciding official shares with the employee whatever that information is, gives the employee a chance to respond, and then makes his decision.
If an employee fails to follow instructions, which results in their failure to meet their performance expectations, and the agency addresses the misconduct in Chapter 75, may they also address it through performance by using Chapter 43?
Well, I would say if you were going to do a Chapter 43, then you do the Chapter 43 with the PIP. And so your Chapter 43 is really based on having failed to pass the improvement period or the demonstration period. If you have separate elements of misconduct that might have impacted on the performance, you can do them, but you need to decide sort of which avenue you're going to take and which avenue best addresses the misconduct and which is going to result in correction of the misconduct. So if it's a performance thing that you need to address, then go ahead and go through the steps of doing the PIP. If it really is a sort of discrete conduct action that just happens to impact on performance, then address the conduct discreetly.
Does the deciding official have to consider the same Douglas factors as the proposing official did?
The deciding official is limited to considering what's listed in the proposal. So the short answer is yes. they're bound by the record. They consider what's in the record, which is comprised of the proposal and what the employees has said or responded. Okay, all right, so I'm going to, seeing no more questions, I'm going to hand it back to Jason.
Thank you, Melanie. Thank you again for sharing your expertise during today's webcast, Charge Writing, an essential building block for defensible actions. Your presentation has provided an outstanding and informational commentary on good charge writing techniques. This ultimately supports the 3 PMA pillars of mission, service, and stewardship by providing some tools to help promote civil servant accountability. On behalf of Deborah Buford, I thank OPM's communications staff for your webcast of the webcast training. Thank you to my colleagues for their work in coordinating this training as well. Thank you for participating today. Look forward to having you at the next Employee and Labor Relations webcast training. Finally, please remember that shortly you'll receive an email with a hyperlink to an online survey courtesy of SurveyMonkey.com. Your feedback helps us to plan future webcast trainings, and we appreciate you taking the time to complete this survey. Have a great afternoon.